Former President Jacob Zuma has turned down a directive by the Constitutional Court to submit an affidavit to argue in mitigation of sentence if indeed he is found guilty of contempt. Now, in his response, the former president accuses the court of treating him in a repressive manner and of employing political gimmicks. Zuma has refused to cooperate with the Apex Court at several turns after also defying the state capture inquiry. This comes amid a cloud cast over Judge Daya Pillay over her relationship with Public Enterprises Minister Pravin Gordhan. There are concerns Gordhan may have tried to use his position to influence Pillay's appointment, which the minister has denied. A whole range of issues unfolding in the judiciary. So do these events impact on the independence of the Apex Court? Let's unpack these issues with Professor Tumi Mmusinyane, who is Associate Professor in the Law Faculty at Northwest University. He joins us now via our video link. Prof, a very good morning to you. Where does one begin to unpack what is unfolding in the judicial landscape at the moment? I think perhaps let's begin with yesterday's developing story. Instead of submitting that affidavit to the Constitutional Court as directed by Chief Justice Mogoeng, the former president sends a 22-page letter effectively saying why he is ready to go to prison.
Good morning, Michelle and the viewers. Yes, it's quite an interesting development that is unheard of, where you are called in to appear before court and to give your side of the story, and you turn it down. And in principle, what the law says is that when you are given that opportunity and you fail to honor it, whatever that is presented against you becomes a fact and evidence that is admissible before the court. But what has happened now is something that it's not even in the rules of the Constitutional Court, where after the Commission has closed its own case, now a special letter is written to the President in the form of an affidavit request to submit reasons why he should not be in prison or what appropriate sanction is required for him to do that. It's something that is unheard of in the legal fraternity in South Africa, and I don't understand why the Constitutional Court, as the last court in the land, would want to do something of that nature in as far as trying to accommodate someone who refused to be given, that opportunity. He refused on several occasions. He has written in so many long, statements, about how he regarded the Constitutional Court as not being, no longer independent, no longer being impartial, and not treating him in accordance with his constitutional duties. It's quite something that is unheard of. I don't understand as to what is it that the Constitutional Court is trying to do, except perhaps to play a political game here, Michelle.
It's very interesting that you say that, Prof, because, you're saying that it does appear that the former president is getting some form of preferential treatment by the Constitutional Court, and that certainly is the perception that is widely held, let's say, in many quarters. But Jacob Zuma himself is arguing the opposite. He's saying that he's being disadvantaged by the Constitutional Court by virtue of who he is.
He is one of those that negotiated for the same constitution. So if he believes that he's been disadvantaged, he needs to do that through a proper channels, not through issuing of statements and in defiance. He needs to challenge that. Court exists for that purpose. But for someone in his position, Michelle, I would honestly understand as to why he will feel a bit uncertain, because how many court judgments has this country has against Jacob Zuma, and how many did he win? So in essence, subjectively speaking, it will be like there's no point, because in each and every case that I have defended against me, I've lost all of them. The recent one that now is that he needs to pay back almost 15 million. And he still now has a challenge to challenge the Supreme Court of Appeal before the same court that he's now accusing of, not treating him very well. It's understandable for him, but legally speaking, Zuma has no leg to stand on. He took an oath when he became the president to abide by the same constitution. Why then, if there is such allegations that are leveled against him, why then, if there are so many judgments that are issued against him, he now starts to rebuke the very same court that he has trusted for so long after so many years? It's quite questionable for him at this moment.
Yeah, absolutely. He paints himself to be a victim of some kind of political conspiracy of which the Constitutional Court is a part of and is playing an active role in. That's what the former president is alleging here. So I want to get your take on what will happen next, Prof, because what the state capture inquiry has asked the court to do is to impose a 2-year jail term if it finds the former president is guilty of contempt for failing to adhere to that directive that he appear before the inquiry itself. Is that an appropriate sentence given the issue at play here? What do you reckon, if indeed it does come to a prison term, that will amount to?
In fact, I'll be surprised if the Constitutional Court, Michelle, will grant the commission the 2-year term, because we are dealing with a statute here that establishes the same commission. We talks about any failure to, comply with the commission's, summons and so forth requires a 6 months jail sentence. It will be interesting as to why would the Constitutional Court move away from a statute that is established to regulate the same commissions and to offer a 2-year term that, understandably, it's not really something that is documented. You rely on what the law says and you apply it as it is. But if you regard to say that the 6 months is not adequate, then the best way is to appeal the same legislation. Not necessarily now to say that, yes, we understand the Commission's Act talks about the 6 months, but we want 2 years. It will be quite really, a dangerous, exercise for them to undertake, considering how, a lot of campaign has been ridden. I mean, in as far as Jacob Zuma is seeing the Constitutional Court at the moment, it will be very much dangerous for them even to consider that 2-year period.
Let's talk about some other issues unfolding in the judicial space. And of course, one of the big stories this morning is the issue around whether Minister Pravin Gordhan did indeed try to use his influence somehow in terms of Judge Daya Pilay's appointment to the Constitutional Court. We understand that this happened in 2016, where Chief Justice Mogoeng described the minister asking whether he could discuss how his friend, Judge Daya Pilay, had been doing in the interview process. We know that the minister himself has now come out and he said it was in passing that he posed this question to the Chief Justice. In your mind, something as serious as using your influence to try and influence the appointment or any appointment to the bench, is this something that should be investigated and taken further?
I think we should really take what Mr. Gordhan has done with a pinch of salt, because particularly when we know that our politicians have infiltrated or put fingers in almost every coffer or corner of the administration. The only thing that is holding at the moment, Michelle, is the judiciary. Now, when we have someone in his position as a minister, having to call the Chief Justice out of an interview to say that, just to ask him about, I understand that he says that, yes, I did meet with the Chief Justice. The first thing we discussed was about the remuneration issue. The second one was about the tax ombudsman. The third one was the Jacob Zuma judgment. While having those discussions, now he says it's incidental. He says it's in passing. Mm-hmm. It's purely English to me, because if you look at the context, in law we look at the context as to what was being said. That is it convenient for him at that particular time when a friend is attending an interview? You decide the person who's conducting the interview, who has an authority, over that interview. Now you ask him and you claim to be in passing, unless we are meant to pass, an impression to say that it's my friend, take care of my friend. It's very dangerous, in as far as that is concerned. Secondly, Michelle, if you look at what happened 12 years ago about the Hlophe issue, Hlophe also called, 2 justices of the Constitutional Court to have a meeting with them to discuss a matter that is yet to be finalized by the Constitutional Court. Will we regard that as something that is improper? Yes, because we found a tribunal has found him guilty of gross misconduct based on that. And this is what happened, Michelle. What I'm trying to contextualize here is that immediately after the meeting Hlophe with these 2 judges, they went and tell other judges that, we met with Judge President Hlophe, and this is what he discussed. Look at now, from 2016 up to now, Chief Justice said nothing to anyone. In fact, this is the first time that, even the public heard about. In fact, I had a meeting of the minister in 2016 to discuss, the subject matter. So it did not really come as him intentional to inform us, because it's very dangerous how we've seen, our politicians try to come closer to the judges. It's very dangerous for him to keep quiet, because the two previous judges did not keep quiet once they had something unsettling about this one. Yeah. Why did the Chief Justice decide to keep quiet and only during the interview now decide to raise this matter as something that is troubling him?
Yeah. Yeah.
We're in a constitutional dilemma here.
Yeah, that's an incredibly important question. In fact, Prof, I want to just get your take on one last issue. You've said several times during our interview that the judiciary is what is holding our democracy together. It's the center. It's what's holding the center. These various issues that have come at the judiciary, attacks by various quarters, the comments, just these recent comments by the former president as well, about the role of the Constitutional Court and the perceived politicking of the apex court. What do all of these perceptions do to our judiciary?
Michelle, they honestly taint the image of the judiciary. If the judiciary is not careful enough, if the judiciary is not honest with all of us as citizens of this country, we are likely to find ourselves in a constitutional turmoil. We are likely to lose all the gains that this democracy has gained up to so far, in as far as the impartiality and independence of the judiciary. That if we don't honestly, our judiciary, wake up, to this issue of a friendship issue is very dangerous. Look at what happened before the Zondo Commission, if I take you back. That Zuma only at the latent stage decides to say that, but Zondo, you are my friend. You've been attending all my gatherings and we've been together. And Zondo said, no, you are not my friend. Look at the impression that it creates. Now, when you take someone of that nature, Judge Pillay, you put him head before the Constitutional Court, and a matter comes that concerns the Minister of Finance. Are you honestly saying that this issue is not going to come up, particularly when you realize that Zondo was not playing to Zuma's corner? That's why he decided to use that as a defense. Now, having this kind of judges that have declared friendships with politicians and the matter comes before them is going to be troublesome, because right now we are having the same problem with Jacob Zuma. This has an impact in as far as our judiciary is concerned. This has a serious implication for our supremacy of our constitutions and people that have been appointed to govern or to regulate our constitutional issues.
Prof, incredibly sound insights there from you. Thanks very much for giving us some context with which to read all of these various developments in the judiciary at the moment. Professor Tumi Mmusinyane is Associate Professor in the Faculty of Law at Northwest University. Thanks very much for your time, indeed.